My name is Joe Mulberg, and in this presentation, I'm going to be informing you about trademark law. In this presentation, you will learn what trademarks are, what trademark law is. You will learn about infringement of trademark law, and I will also explain to you a recent breach of trademark law. Trademarks are words, designs, devices, shapes, and packaging of goods that are attached to any kind of a good or a service that a business is delivering or selling to a customer. Typically, when we think of trademarks, we can think of a Nike swoosh, or we can think of a slogan, if we continue on with Nike, like "Just Do It." We can think of Skittles and the various colors used in the package of candy, and we can also think of their slogan, "Taste the Rainbow." Some trademarks are considered well-known, such as the ones that I just mentioned. A well-known trademark is one that the general public, they have a higher association between a sign and the good than smaller or more ordinary trademarks do. So one important question to answer is, when did trademarks start? And while we don't have any kind of legal document recording when they first started, there have been many people who have gone back and excavated sites and found symbols carved into pottery. And so what we can learn from this is that certain potters, at the beginning of circulating goods, when this first started to occur in history, we see that inscriptions were made, somehow separating one potter from the next. And we can assume that this went on in not just pottery, but in a whole bunch of goods that were distributed through bartering or selling. In the United States, the Trademark Act of 1905 was put in place by the Patent and Trademark Office. This specific act prevented, and I quote, from reproducing, counterfeiting, copying, or colorably imitating goods with registered trademarks. Now I want to take a look at this. Reproducing the same product that somebody else made could not be reproduced. Counterfeiting, you couldn't take that good and try to match color for color and design for design with what somebody else has already patented. You couldn't copy a logo or a slogan. And notice this, colorably imitating. Earlier I mentioned the color on the package of Skittles, or the color of the Skittles themselves, and even the logo on them. This would not be something that would be allowed to be imitated by a similar company or business as well. The Lanham Act of 1946 was put in place to protect against consumer confusion. And that word consumer confusion, for many people, it creates a problem when they think about trademark law, but we'll break it down. The word consumer confusion in its original use here is confusio mentalis. And specifically what these words are referring to is when a consumer, picture somebody walking into a store looking for a certain good, and it occurs when they're put into a state where they're going to be prone to misjudge and behave differently than they typically would. So they walk into a store looking for a Mountain Dew, and they make their way to the drink aisle, and there may be another drink in the same area or in the same aisle, and that drink uses the same colors as Mountain Dew. The liquid inside of the container is the same color, the same shade of yellow. The design on the label looks very similar as well. And that customer is going to have to stop and think a little bit. And they're going to become confused because they'll notice possibly some minor differences. But the confusion mostly happens where they went in there for a Mountain Dew and they're struggling to figure out which one might be what they're after. And therefore, their decision-making process is different than it typically would be. We call this the confusion problems. In the last slide, we talked about the confusion problem that occurs when a trademark is infringed upon. Currently, what is considered to be a trademark is expanding, specifically with the rise of technology. And with this expanse, the confusion test, which we'll talk about, must continue to expand its requirements. The confusion test we talked about in the last slide. A customer who walks into a store, goes to the drink section, and is looking for a Mountain Dew. And it takes them a little bit longer, and they start to get a little confused because as they're looking for a Mountain Dew, they see another product that looks very, very similar. When a sufficient number of customers are likely to confuse one trademark for business A with a trademark of business B, that's when we have some problems. Now, specifically to do a confusion test, the court will examine the reaction of customers to different goods or services and their trademarks, trying to figure out, are they confusing one good or service with another as a result of trademark infringement. However, not everybody is on board with the confusion test. I quote, in 2006, Professor Barton Beebe, he described it as being in a severe state of disrepair. And for many, this is how they feel about the confusion test, that it is not a sufficient way to measure infringement upon trademark law. However, it is a difficult way to, I would say it's difficult to measure infringement on trademark law at all. And I would say it's a good place to start somewhere. I mentioned that with the rise of technology, there is a larger need for more specific focus on what trademark infringement is. And more recently, there has been a protection act titled the Anti-Cyber Squatting Consumer Protection Act. Let's say that again, Anti-Cyber Squatting Consumer Protection Act. And what this specifically focuses on is protecting trademarks on the internet. Cyber squatting, it occurs when an attempt is made to confuse customers from one trademark owner's site to another. When I was applying for federal aid, I remember my mom, she created an account on a website that was made to look like FAFSA's website. And we were in the process of giving them all my information. And this would be, I believe, an example of cyber squatting, trying to resemble one website that has already been established and establish a trademark. When somebody does this, it's going to result in a consequence from the ACPA. And this will definitely result in consequences when it's done out of bad faith. And the ACPA, for clarification, is the Anti-Cyber Squatting Consumer Protection Act. Now I want to share with you about a recent breach of trademark law. As I was doing research, I found this breach to be particularly interesting. I enjoy sports, and much of our country does, and I thought this was pretty relevant to a lot of people. I went to a school, and we were called the Fairfield Indians, and I remember different people throughout my time going there, hearing them talk about, oh, your school shouldn't be called the Indians. And close to my house, there was a school called, it was a district, they were called Talawanda, and their mascot was the Braves. And I remember hearing a lot of fuss about that, and there's been things about the Cleveland Indians. And specifically, we're going to focus on the Washington Redskins. The United States Patent and Trademark Office, they've been in process to attempt to cancel 6 trademark registrations for the Washington Redskins. Now, I have Redskins in quotation marks up here on the slide because specifically the Redskins is what the trademark is that the United States Patent and Trademark Office is attempting to cancel. The reason for this is a group of Native Americans claim that the trademark Redskins was in a violation of trademark law. In the next few slides will explain what this violation looks like. Section 2 of the Lanham Act states that there's a prohibition for registering trademarks that may disparage persons or bring such persons into contempt or disrepute. Now, specifically, Native Americans are saying Section 2 is what proves that the Washington Redskins trademark, the Redskins, violates trademark law. Below are 2 questions that need to be addressed to see, in fact, if this trademark law could be upheld. The first question is this: what is the meaning of the matter in question? And specifically, the meaning is that Redskins does refer specifically to a certain group of Native Americans, without a question. And the second one that we can take a look at is the meaning of the marks one that may disparage Native Americans? And the answer to this question is definitely yes. Many Native Americans find this term derogatory, find this term demeaning, very negative. Now, let's talk about consequences of the decision that was made to cancel these 6 trademarks. So if the Washington Redskins are not successful in defending their trademark in court, there will be 3 major results. The first is that they will still be able to use the trademark. However, it will not be protected. And the fact that it won't be protected means that others are going to be able to use that trademark that's no longer protected in ways that will start benefiting them. I think about how expensive a shirt is with my hometown football team's logo on it or name on it, an official shirt. And I think many reasons for that include they have the rights to it. And losing that trademark, I believe, will allow for many other companies to come up and compete for business at a lower price. Now, the Redskins, however, will have to start looking to other laws to enforce property rights and hopefully not lose this trademark or this name or the right to be able to be supported by law. I want to thank you for listening to the presentation. I hope you were very informed on what trademark law is, on how it came to be, and I hope you were also informed and interested in a current aspect of trademark law that is being breached and some attempts being made to defend and continue on in using such a trademark.